Hello everyone, and thank you for joining the final week of the Signal Center's Accessibility Awareness Series. Signal Centers is located in Chattanooga, Tennessee, a gig city on the Tennessee River, and ranked as one of 2019's top 100 places to live in America. Signal Centers provides technology, accommodations, and training to help individuals with disabilities live their best lives. Here is CEO Donna McConico.
Hi, I'm Donna McConico. Welcome to the Signal Center's Accessibility Awareness Summit. Last year, at our very first summit, our keynote speaker, Haben Girma, said this: "The problem is never the disability." She was right. We are living in the midst of a technology renaissance, and we must be the leaders insisting that this movement is for all. Accessibility is within our reach, and it will take persistence and creativity to fully embrace all of the possibilities that technology offers for individuals with disabilities. Thank you for joining us again this year to continue the conversation about accessibility.
This webinar series would not be possible without the support of our partner and host, Chattanooga State Community College. With an enrollment of more than 8,000 students, Chattanooga State offers more than 100 degree plans. Its digital accessibility mission statement is a commitment to provide all individuals the opportunity to use technologies. Here is Vice President of Academic Affairs, Dr. Beth Norton.
Chattanooga State hopes this conference series will inspire transformative conversations about the inclusion of all individuals in the ever-changing world of digital technology.
Signal Centers is grateful to the following sponsors: McKee Bakery, Unum, Phil Hour, Electric Power Board, Tennessee Council on Developmental Disabilities, AT&T, and a special thank you to Blue Cross Blue Shield Tennessee for sponsoring today's sessions.
You know, when I think of Blue Care, the phrase that always comes to mind is, "We make a difference." It's really become a mission and a passion for this division to figure out ways to promote healthcare. We really want to make the lives of our members better. We promote a population health management model, meaning we integrate and coordinate a member's total physical, behavioral, and long-term care support and services needs. We're also looking to expand our program for our intellectually and developmentally disabled population. I'm really proud that we've been in this program for 22 years and now serve as an industry leader. I'm proud that we have been a good and trusted partner to the state of Tennessee. I'm proud that we've improved the health care in the state of Tennessee for so many members, but probably the thing that I am most proud of are each and every one of our 1,200 employees that work within Chattanooga, in our regional offices, in our communities. I see them approach their work every day with a passion, an energy, a drive, because they know they can make a difference. And I think that's how we support the mission of peace of mind through better health.
And now, in recognition of Global Accessibility Awareness Day, Signal Centers welcomes Stacie Price, Access Attorney at Disability Rights Tennessee, advocating for enforcing the rights of individuals to be free from discrimination based on disability, and Attorney Stacie Caraway with Miller & Martin Law Firm, advising employers of all sizes on how to comply with state and federal laws while still effectively running their businesses. With today's presentation, Accessibility Trends.
So again, I'm Stacie Price. I'm an attorney with Disability Rights Tennessee in Nashville. And just a little disclaimer, or they would probably tear up my bar card, that this presentation is intended to provide you with some general information about accessibility trends. Nothing in the presentation is legal advice. For legal advice, just you can contact your own attorney for that. All right, so just a little intro. I know you got a little bit of taste of what Disability Rights Tennessee is in the lovely intro, but we are the state's protection and advocacy organization. So by Congress, each state and territory is required to have a protection and advocacy agency. And what that means is that we advocate and protect the rights of individuals with disabilities throughout the state. We are legally based, so we have attorneys, we have advocates, and all our services are free of charge. We deal with things like abuse and neglect, education, access, and right now we're beginning a pretty narrow focus on COVID-19 related issues. So there'll be some information at the end if you have a need to contact, or you can refer us to anyone. We're happy to have you do that. All right, so let's get right into it. This is a really appropriate time again to talk about the Americans with Disabilities Act. That gentleman they're signing that did so, and that's George H.W. Bush, so Senior, is the picture of him signing the Americans with Disabilities Act in the Rose Garden of the White House. And that was almost 30 years ago today. It was signed on July 30th of 1990. I almost said 2000, 1990. So it is a 30-year-old statute. So one of the most important civil rights statutes to come down the pike, certainly in the last 30 years. So the ADA was enacted in 1990 to eliminate discrimination against individuals with disabilities. And prior to 1990, there was a few acts that protected the rights of people with disabilities, but nothing quite to the extent of the ADA. Prior to the ADA, folks with disabilities really could not access things like other people without disabilities could. There was no accessible parking, or if you went to the doctor and needed an interpreter if you were deaf, there was nothing that required businesses, places of public accommodation, state and local government entities to provide that. So that all changed with the Americans with Disabilities Act. There are a couple of other important federal statutes that deal with elimination of discrimination against people with disabilities, like the Rehab Act, which is kind of the same as the ADA, only it applies to entities that receive federal funding. And the Affordable Care Act also has a little section dealing with disability discrimination. But for today's purpose, we're going to be focusing on the ADA. Okay, who does the ADA cover? And of course, an individual with a disability. And what does that mean? It means a physical or mental impairment that substantially limits one or more of the major life activities, such as seeing, hearing, and walking. And there's a laundry list of major life activities, from eating and sleeping, self-care, learning. So it's a pretty broad definition. And the ADA also covers companions with disabilities. And that means a family member, a friend, or an associate who is an appropriate person with whom the entity should communicate. So a lot of times companions come in under the effective communication section of the ADA. For example, if a married couple went to a hospital and the wife, who's the patient, was hearing and her husband was deaf, and he's not the patient, but he would be considered a companion under the ADA that is required to have effective communication as a support person for his wife and to communicate with healthcare providers. All right, who must abide by the ADA? So I'm going to be talking about primarily Titles 2 and 3 of the ADA, which I'll go into detail about. Stacie C will be talking about Title 1, which deals with employment. So Title 2 of the ADA, that covers local and state government entities and their agencies, such as DHS, DCS, public schools, public libraries. Anything county or state related is going to fall under Title 2 of the ADA. There are certain more, I don't want to say protections, there are certain protections under the Title 2 that don't occur under Title 3, and I'll kind of note those as we go. Okay, and Title 3 of the ADA is kind of like the bucket list. It covers what's called places of public accommodation, which include hospitals, healthcare facilities, physicians, attorneys' offices, bowling alleys, gyms, amusement parks. Pretty much anything under the sun is going to fall under Title 3 of the ADA. What does the ADA require you to do? So the main tenets of the ADA are equal access to goods and services. So businesses, state and public entities must provide individuals with disabilities equal access to goods and services. They also must provide appropriate auxiliary aids and services free of charge to ensure effective communication with individuals with disabilities. And businesses and places of public accommodation, state and local governments may have to modify their typical practices or policies in order to provide reasonable modifications to people with disabilities so they can indeed access goods and services. So let's talk a minute about auxiliary aids and services. Again, they must be provided free of charge. They can include things like qualified sign language interpreters, note takers, captioning, video remote interpreting, instant text messaging, or it can be as simple as a piece of paper and a pen. So there's a broad spectrum of what fits into an auxiliary aid and service, and each person with a disability is unique on what they need for equal access. All right, so here's one of these little nuances I was talking about, that there's an extra protection in Title II and in medical, and this also applies to medical providers. So state or local governments and medical providers must give primary consideration to the requests of the individual who is deaf or hard of hearing, or a person with a disability, when choosing an auxiliary aid or service to provide. So you must first take into account what that person with the disability is requesting. You can't just make the decision for them. You've got to take, which is a good rule of thumb under Title III as well, but it specifically says in Title II that you have to give primary consideration to the request of the individual with disabilities. But the ADA does permit the state or local government or the medical provider to offer an alternative auxiliary aid if those will provide the individual with effective communication. So in the end, you can pick which auxiliary aid you're going to use, but you have to make sure it's providing effective communication. If not, there'll be a violation of the ADA. All right, the ADA does not require a covered entity to provide an auxiliary aid or service, or to change their policy in two circumstances: if doing so would create an undue financial burden or administrative burden, or if doing so would fundamentally alter the nature of the services. I will say these standards are very difficult to meet and are rarely successful in defeating a covered entity's obligations under the ADA. Another nuance in Title II, state and local government entities must write a letter saying why the particular accommodation they can't provide causes an undue burden. So there's a specific burden on state and local governments to explain why. All right, so another thing, modifications to policies we've talked about. A business or a government entity may want to come up with a non-discrimination policy, an effective communication policy that explains how someone can request an interpreter. You might want to think about having a service animal policy. There's lots of hot topics around service animals these days, so that's something to look into. A good idea is to provide forms for folks to request modifications, and to have signage up in your buildings on how someone can request a modification. All right, so let's talk a little bit about the hot topic of the day on everybody's mind, whether we like it or not: accessibility in the age of COVID-19. Lots of issues have come up since the COVID-19 pandemic has been around, and I think we're going to continue to see an increase in accessibility issues. So media briefings are obviously extremely important right now. We're getting daily information about numbers and what's reopening, what's not. So you have to keep in mind these briefings have to be accessible to individuals with disabilities. For deaf and hard of hearing people, this means having an American Sign Language interpreter in camera range at all times, kind of like what we're doing here on the webinar, and having closed or open captioning available. And just a little caveat, we've had some clients have called in and said the closed captionings are up on these videos, particular videos, but they're in run-on sentences and they're hard to read, and sometimes they leave off information. So do check your closed captioning. Make sure they're in compliance with the Web Content Accessibility Guidelines, www.w3.org. So you might just make sure, just because you got those closed captioning up, they're also readable. Another thing, believe it or not, a hot topic that kind of came in during all this COVID is fast food drive-through service. Everybody was shutting down their dine-in areas, but folks could still go through drive-throughs. Well, if you can't drive, or if you're deaf or hard of hearing, it's going to be very hard to order at a drive-through window. And so there was a lot of folks that were being turned down service. So we suggest, and we sent letters out saying, go ahead, put a sign up on your intercom stating that you can drive around or walk around for service at the window. You can allow customers to write down their orders on their phone or on a piece of paper and show them to the cashier so that you can still have access to fast food services. All right, telehealth are also big deals right now. And again, that's great for folks that can do that, but for deaf and hard of hearing people, there's an interpreter that is needed for those, or if folks have cognitive disabilities, it may be very hard to communicate over the computer. So that means that you might allow a reasonable modification for a person with a disability to come into the office. Of course, take precautions, social distancing. If you have a deaf client, a qualified sign language interpreter can be at the office with the healthcare provider, or you can have them on a Zoom meeting. We've seen that too. All right, a good time, since we're talking a little bit about healthcare and deaf and hard of hearing individuals, a good time just to mention video remote interpreting, which is an off-site remote interpreter that is accessed through a computer or a tablet. So kind of like the picture set up here. You would have the healthcare worker and the patient in the same room, and then the interpreter would show up on a video screen. And this, of course, is going to be more widely used during COVID. But there are very stringent federal regulations on that. So if you have a video remote interpreting program or a VRI, you must ensure that there is a strong connectivity so the picture on the screen won't lag or be fuzzy. You must train staff on how to use it and set it up. And remember, if you are a healthcare provider, you must give primary consideration to the choice of the individual with the disability. Some folks have had a lot of bad luck with VRI in the past. They may be hesitant to use it. They may request an on-site interpreter. You do have to take that into consideration. But I think the more that we can ensure VRI is working and that staff is trained on it, the more the deaf community will feel comfortable using it, that it will provide them with effective communication. All right, so here's a kind of a really timely thing that kind of came in to, I guess, as an issue during COVID-19. Back in 2016, Tennessee issued guidelines for the ethical allocation of scarce resources. And so this was way before the COVID pandemic, but they weren't coming into play until this happened. And they said that healthcare providers may exclude people with advanced neuromuscular disease who require assistance with activities of daily living or who require chronic ventilation support from accessing critical care, including ventilators. And they also excluded people with metastatic cancer, some with dementia, some with traumatic brain injury. I think MS was also on the list, from necessary care, including ventilators. So these guidelines just made a laundry list of certain disabilities and said, well, we can exclude you from getting a ventilator if it becomes scarce. So obviously, those guidelines discriminated against people with disabilities. I mean, there's thousands of people who have the listed conditions on those guidelines who are not inherently less likely to respond to COVID-19 treatment or medically less capable of surviving and returning to living productive lives. So it came down to these guidelines were strictly grouping of people with disabilities together and making a decision because you had that disability that you were blocked potentially from getting a ventilator or whatever. And you just can't do that under the ADA. That's discrimination. You have to have an individualized assessment of the person, obviously through their medical provider. And so a group of us included DRT with a group of our other sister agencies filed a Department of Human Services complaint, and the guidelines were taken off the state's website, and I think they will be issuing new ones shortly. All right, so another big topic is support persons for individuals with disabilities. So when COVID-19 came out, all of a sudden you were hearing no visitors in the hospitals, even dads whose wives were giving birth or significant others were giving birth can't come in, no visitors at all. So that created a lot of problems for people with disabilities, especially people with cognitive impairments or intellectual disabilities or communication disabilities, because they need a support person with them sometimes to explain their medical care, support them in their healthcare process. Most hospitals actually did, if you look on their website, the major hospitals in Tennessee do have an exception for persons with disabilities to have a support person with them. And then just on June 3rd, 2020, the DIDD department and DOH issued a letter strongly encouraging all Tennessee hospitals to adopt policies that would allow a designated support person to stay or visit a person with a disability. All right, but just as a checklist, if you are wanting to go in as a support person for a person with a disability, or if you're a person with a disability who would like to take a support person with you, check the hospital's website, see what their policy is ahead of time, call ahead, say, I make your case that, hey, I'm a person with a disability and I need this support person because of, X, Y, or Z. If they don't allow it, maybe go to the nursing supervisor. Once you're allowed to have a support person, get that in your chart and just be aware that support person's going to have to follow guidelines, wear PPE, maybe not leave the room, just to take those safety precautions. All right, so that concludes a little COVID-19 talk. Now I just want to go over a few general trends in accessibility. I'm going to start with education. If there's any educators out there or people who work in the school system or don't, this is still some things I guess to think about. So there is what's called the Tennessee Early Intervention System, or Operation Manual for Field Staff. And in that manual, their TEIS manual, it states that any AT device for a child between 2.5 and 3 are not covered because equipment requested during this time would not be available long enough to achieve identified goals. So if you think about it, a child who is between 2.5 and 3, that's when language is just booming for that child. That's when words are being learned, words are together. Yet for that 6-month period, there's going to be no provision for any accessibility technology device. So leaves these children without AT assistance at a time of critical learning and language acquisition. So that's something that I think needs to be changed. And so I just wanted to make everyone aware of that. Also, education, another big issue is AT devices for communication, especially for kids who are on the spectrum or have other communication disabilities. We're really seeing a need for an AT device to be an integral part of the IEP and the Behavioral Intervention Plan, or BIP, because the things go hand in hand, right? The AT device is going to be helping that child who may have a communication disability communicate. And therefore, with that communication, hopefully will help with a behavior that may be occurring because communication isn't happening. So a child needs to have the AT evaluation, and then the AT needs to be incorporated into the IEP or the BIP, and then staff needs to be trained on how to use the device. So all of it should kind of go together. Of course, parents at home need to take the responsibility to learn the AT device, but we're really seeing a need for that AT device to be part of the behavior plan and the IEP. Okay, a couple of just kind of cool devices that I wanted just to point out. The Kurzweil 3000 is a multi-sensory approach to literacy. It is a platform for reading comprehension and for learning that has lots of cool features. It has customized reading rates so you can slow it down or speed it up, highlighting options, dyslexic font if you have dyslexia, magnifying text for people with low vision. So this is a great new reading tool out there. Of course, also for education, there are programs at the very top right that is called the GHOIT Read Writer for literacy software for people with or kids with dyslexia. It has severe spelling error correction. So I thought that was kind of cool. And then we've actually gotten some calls recently about eye gaze machines. If you'll notice in the bottom right, the young child is using the eye gaze machine to paint the picture. And then, of course, in the left, you have a little girl who's operating a screen through a mouth tube. Especially some of these, and I will say some of these AT devices like the eye gaze are expensive. And a lot of times schools don't want to have the liability of having this expensive equipment. But if the child needs it to communicate and to learn and to be successful and to have an individualized education plan, then we encourage the schools to let that child have that and let staff be trained on it. Often parents will sign a waiver, saying that the school's not liable if it gets lost or broken. But we do encourage schools to go ahead and allow those into school for the child. All right, and also a big thing right now is virtual assistants, which can provide services from a remote location, and it may be used for distance communication. I'm not affiliated with any company, not promoting anything, but things like Amazon Echo on the left and Google Home Hub on the right. There's also Apple HomePad that allows you to make video calls and audio calls right from home. And this is one of the coolest, next slide, this is one of the last slides. One of the coolest things I've seen and heard about lately in accessible technology, or AT, is, I may not say it right, ARA.io, AIRA.io. And this is a device for a blind individual. I actually saw this in person. I went to the ADA symposium last year, and there was a gentleman who was blind who had these glasses on, like what you see on the left, and he said it's kind of like a VRI that deaf or blind people. Remember, the VRI is for a deaf person to communicate with a hearing person. This is kind of like a VRI for a blind individual or low vision. You put the glasses on, and there's a little camera that's connected to a remote assistant, and that remote assistant will be seeing for the blind person. And so they may go to the mall and they'll say, okay, walk straight, there's a fountain, turn right, you're looking for whatever store, you're looking for Starbucks, continue right, and then turn. So anyway, there's a set of seeing eyes for you in the glasses. And this gentleman at the convention was telling me he was able to go and buy his wife a ring as a birthday present all by himself. So I thought that was really cool. So if you want to check that out, that's the website for it. And then also really great tool for deaf blind is I Can Connect. They're a national program that provides people with significant hearing and visual loss with free equipment and training, and that's the website there. So check that out. And that is it. Thank you so much. That is Disability Rights Tennessee's contact information. We have a Get Help at web address there. That is my information. Feel free to call me at any time, especially about any COVID-19 related issues. Thank you.
So my name is Stacie Caraway, or Stacie number 2, as I'm going by in this presentation. So just want to wrap up by talking about particularly accessibility issues in the employment context. My job is a little different than Stacie Price's in that I am usually the person that is advising individual employers when they have a disabled individual who is coming to them as an applicant or is currently working for them as an employee and is saying that they need certain types of accommodation, whether that be in the particular accessibility realm or other. So just to give you some context as to the frame of reference that I'm coming from today. So give you the same disclaimer. I think all lawyers, this is what they give you the first day of law school. So just a quick disclaimer again. This is intended to be just kind of general education information and is not intended to obviously give you advice about your particular situation. And if you do need that type of advice, as Stacie Price explained, certainly feel free to reach out to your own individual attorney. So as Stacie Price explained, there are 3 sections to this federal law that the first President Bush, George H.W., signed, which is the Americans with Disabilities Act. The section I'm going to be dealing with is Title I, which focuses on the rights of disabled individuals in the employment context. The good news is that you use the same definition of disability in all 3 titles. So I've given you some of the same examples that you saw earlier in Ms. Price's presentation. Added a few others, as Stacie Price explained. Basically, any condition that substantially impairs, whether it's an organ, a bodily system, or a function, whether that's concentrating, walking, etc., can qualify as a disability under, again, all 3 titles of the ADA. There are a few differences, and here just references what the other 2 titles deal with, as Stacie has already referenced earlier. But a few of the differences are when you're asking for an accommodation as an applicant or as an employee, you have to kind of fall into this, what I call kind of narrow window or kind of in-between area where you have to have a disability, obviously. You can't just, and I say that because we do have situations where people will ask for assistance in situations where they don't really have a qualifying disability. Maybe they have a very temporary condition. As I'll refer to later, the EEOC, which is the Equal Employment Opportunity Commission, which is the federal agency that enforces the ADA with regard to employers. So they've kind of come out with a mixed message about whether, we talked a lot about COVID today, whether COVID qualifies as a quote disability or not, because it's normally a short-term illness. So normally to have a disability, it has to be a longer impacting situation than just, a couple of weeks. So you have to fit into that narrow lane, so to speak, of that that your condition is substantial enough to bring you under the protection of the Americans with Disabilities Act. However, you also, the reason I say it's kind of a narrow lane is you also have to be qualified to do the job that you're seeking, either as an applicant or as an employee, either with or without what's known as a, quote, reasonable accommodation. And we're going to talk a little bit later about what the government's definition of a reasonable accommodation. So you can't just say, hey, I want this job and you have to give it to me because I have a disability under the ADA. If you don't fit, that you would meet the first criteria of being disabled, again, assuming that you have that substantial limitation of a major life activity, but you may not meet the second criteria, which is just as important, which is You have to otherwise be qualified for the job and only need what's known as a reasonable accommodation to do that. Another difference is illustrated on this slide. Stacie Price talked a lot about the rights of companions and family members under Titles 2 and 3 of the ADA, but under Title 1, when it comes to employment, there is no such thing as like an accommodation for a family member or a companion. So if you have, for instance, a disabled child and you need time off work to care for that child, that would fall under, we'll talk about a little later about another law that you may be able to qualify for some accommodation under, but you would not qualify for accommodation under the Americans with Disabilities Act to care for a family member or even just a companion. Like if you have a paid position where you're assisting someone, you couldn't take time off of your job with ex-employer to be able to go and help that other person on your quote side job where you serve as a interpreter or et cetera. So that would not fall under an accommodation under the ADA or from the employment perspective. So when we talk about accommodations in the employment perspective, there are really three different areas. We're going to spend most of our time on number 2, because that's what I spend most of my time dealing with is accommodations which allow people to be able to perform the essential functions of the job they either are in or the job that they are wanting. But just to make you aware, there are 3 different types of accommodations under the ADA. Accommodations in the application process. So in talking about this to accessibility, let's say that you're on a business's website and you're trying to click on the careers section in order to apply for a job. There should be an audio section there where you can click on and it gives you like a 1-800 number where you can call and talk to someone. So there are accommodations in the application process. We're not going to talk a whole lot about those today, but I did want to just make you aware that those are part of the protections of this federal law we're talking about. So as I said, most of our times we'll be talking about allowing people to perform the functions of the job, which is what allows you to have or get that job. Going back to what I said earlier about being a qualified individual, this is kind of what I was talking about. You have to be able to show that you can do the job with an accommodation, but that with that accommodation, you have the skills to do that job. And then the last type of accommodation is one that a lot of employers unfortunately forget about, and that is accommodations that allow disabled individuals to have the same access to, like, just going to a meeting, or maybe there's a company outing at Dollywood or something, and it's like, well, everybody was driving their own cars and no one thought about the fact that I was going to need a ride. So things like that can allow an employee not just to come to work every day, but also to take advantage of the same benefits that other employees get of socially interacting with others, etc. So how do you trigger this process? What happens? How do you get an employer to engage with you to talk about, hey, I'm having difficulty doing this part of my job, or as an applicant, I've gotten the job, or I think I'm qualified for the job, but I'm having difficulty filling out the application, or I can't do the interview in the traditional sense. So basically what you need to do in that instance, obviously, is just make the employer aware. There have been some ADA lawsuits where the issue was that the employer simply did not know that there was a need. The employee or the applicant just assumed, well, I assumed that once I told you I had X condition, you would just know that you needed to give me all these accommodations. And, employers don't have that knowledge. So they're not required to just, to be experts in every disability. So if you have a situation where you need assistance, it's your responsibility as the applicant or the employee needing assistance to let the employer know about that. Now, obviously, there is an exception. If you're a blind individual, and you're asking that, to bring a seeing eye dog or to have a cane, or if you're an individual that doesn't have your lower limbs and you're asking to use a wheelchair, you don't have to bring in a note trying to explain why you need a wheelchair or things that are quote obvious. But again, you got to be mindful that an employer who's never dealt with, particularly maybe your type of disability, things that are obvious to you may not be obvious to them. So again, I always kind of urge people to give employers the benefit of the doubt. You may be used to dealing with your situation since birth or for several years, and this employer may never have even heard of it. So, some people assume that employers are like out to get them, or they don't want to accommodate, etc. And sometimes it's just a lack of knowledge, and that's why I really love Stacie Price's organization and others like it that can really help employers, along with somebody like me, kind of help them do the right thing when they call for advice in these areas. So there are some situations, though, and I also kind of always like to point these out when we're talking about accessibility or accommodations is, employers cannot always offer an accommodation. So, unfortunately, I've had, several situations in my 20 some odd years of doing this where, there just wasn't the right fit. No matter what we try to do, there are some situations that cannot be accommodated. So, for instance, violence, telling an employer, I don't know when I can be at work. I might be here tomorrow, but I might have a migraine or I might have this, and I don't know if I'm going to be able to show up or not. As you can probably logically think through, an employer really can't accommodate someone who just has no idea when they're going to be at work. I've made a little reference here to the other law that I made reference to earlier, where I said that the ADA doesn't cover companions of family members. There's a separate federal law that obviously we won't have a lot of time to talk about today called the Family Medical Leave Act, the FMLA. And that law now it only provides leave. It does not provide other types of accommodations like the ADA does. So again, if you had a disabled family member and you needed to take time off of work to help that person, maybe they've had a flare-up and you've got to take them to the doctor, or you need to take them to be fitted for a new prosthetic or a new wheelchair or whatever. All those type of things, you could get leave under this FMLA law. Now, this law, unlike the ADA, you have to have been with the employer for at least a year. You have to have been working for at least 1,250 hours in the past year. And then your employer they have to have at least 50 employees within a 75-mile radius. So you haven't heard us talk about any of those kind of credentials with regard or requirements with regard to the ADA. The ADA, the employer only has to have 15 employees. So, and as I said earlier, applicants are even covered. So there's no time of service or anything like that that allows you to be qualified to get accommodation under the ADA. But the FMLA, there's this 1 year service requirement for 250 hours of work, and then the employer has to have 50 employees, not total, but within 75 miles of where you are. So just kind of be mindful that I just want to mention that other law, because if you need time off, it could be including kind of unpredictable time off. You could get up to 12 weeks of that limited time off as an accommodation under the FMLA. But again, you can't just get like an accommodation forever to just come and go to work whenever you need to under the quote ADA. There's some others like sleeping on the job, having unpredictable seizures, etc. Those type of things. May be things that an employer is not able to accommodate. Now, again, if you have one seizure a month or a year or something like that, that's not what we're talking about. We're talking about somebody who has maybe several seizures daily, weekly, etc. Even in situations, though, that an employer believes may fall under one of those, I just can't accommodate, this is impossible type of scenarios, I always urge them, that should be the last resort. You shouldn't start from the premise that, oh, this is impossible, it's too difficult, I'm not going to help this person, etc. So, you should still try to work with the person to the extent that you can. Some other interactive process tips. That again, the employer is not required to just assume that anything that the employee. So let's say that an employee has come to the employer and said, I have PTSD, and then they start having customer relations issues, or they start having issues where they're not being able to get along with their coworkers. The employer is not required to just assume that any issue that employee has on the job is relating to their stated disability. Again, it's an education process. So, what you need to do is the first time you're called in to be written up for something, you need to let the employer know, hey, this is because of my PTSD, or whatever it is. Let's say that you're having difficulty concentrating or with accuracy. The best case scenario is that you let the employer know before it starts affecting your work, so that the employer and you can already start having those discussions again about accommodations, maybe having a checklist besides your computer, of the things, where some people might just automatically know, do step A, step B, step C. You may need to have in an accommodation a checklist that says, okay, step 1 is this, step 2 is that, step 3 is that, to help you remember it, etc. So, that would obviously be a very easy type of accommodation. But if you don't make the employer aware that you're having those either maybe memory issues or concentration issues, and then you start getting written up, sometimes it can be too late by that point, because if you already get to the point, maybe you make a mistake that costs the company like millions of dollars or something, such that you're already at termination level. Well, if you're already at termination level, the employer is not required to rewind the clock and go back and not fire you because, you didn't make them aware timely about, the possible effects of your disability on your job. So, this is the reason a lot of disability advocacy groups recommend letting your employer know about an issue as soon as possible, because you don't like, it's one of those, doing it too early versus too late can have really bad ramifications for a disabled individual. The next thing that a lot of people don't realize is that employers can't make, whether it's a disabled employee or any employee, take medication, or you need to be using that cane, or instead of trying to walk with a walker, you need to be in a wheelchair. They can't order you to do certain things that are relating to your disability just to maybe make them feel more comfortable. However, and this is the next one, they do have the right to engage in an interactive process, so that if let's say that, going back to the wheelchair versus the walker, let's say that there are lots of wires or something where using a walker could be a tripping hazard, whereas, and again, maybe the type of wheelchair, they're able to put things down where the wheelchair can get over the wires or whatever more easily. So the reason it's called an interactive process is the employee or the applicant is not really permitted to just come in and say, this is what you've got to do. I don't care how much it costs. And this is what my last employer did, or this is what I had when I was in school, and you have to do this. That's not how it works in the employment context. In the employment context, it has to be kind of an exchange of information where certainly, as I said earlier, the employer is not an expert in this area, so they're going to need the assistance of maybe a rehab person, a doctor, certainly the applicant or the employee. All of you should be working together, but it's not like a list of demands where you just say you have to do this and this is the way you have to do it, and if you don't, I'm calling the EEOC or whoever. It's supposed to be interactive to kind of explore a lot of different issues. So if after an employer tries to allow the employee to work, again, let's say that the employee says, I don't want to use a wheelchair, I don't want to use a walker, I just want to do this my way, and and then the employee can't perform the essential function of the job, doing it, quote, their way, For instance, I've had situations where a hearing impaired individual didn't want to wear a hearing aid, and so, like in a particular situation, the impaired individual was like yelling, like people's social security numbers and very confidential information in like a bank or a credit union setting. Well, obviously, the employer doesn't have to accommodate that where people's private information is being yelled because the person refuses to wear hearing aids. So that's just again an example of that. While the employer needs to be flexible, they don't have to allow a disabled individual to just do it quote their way if doing it their way causes issues with customers or again the violation of privacy rights, danger to other people certainly, and that sort of thing. As I said earlier, this is an interactive process, so one thing to always remember is that it's ongoing. So just because what the employer and the employee agreed to at the beginning as an accommodation, things may change. So that's not in stone. So just because that an employer says maybe at the beginning of your employment, hey, we think we can do this. If they try that and it doesn't work, you don't then have a legal right to say, well, they offered this to me and, I have to have this and I liked it and I don't really care if it's not working for the employer or not. Again, that's the interactive part of this. One thing that we're seeing now with COVID is some of the accommodations that employers were able to afford when the economy was going great and everybody was blowing and going, they can't afford now, because COVID has so impacted them economically that they honestly cannot afford some of the accommodations that they were able to offer. So again, it's a constantly changing process. Some accommodations which started out being effective, they lose their effectiveness. Maybe the disabled individual's disability gets more intense, so that what was offered at the beginning isn't effective anymore. So that's the reason that we talk about it being an ongoing process. We also talk about that it's important to memorialize what's being offered and what's not in writing, so everybody's on the same page. There's nothing worse than an employee thinking, oh, I thought I could just come and go as I pleased, or I thought I could come in late to work every day, or I thought I could leave early every day, or I thought I didn't have to do this part of my job. And the employer's like, well, no, that was just something we offered for a few weeks, while you hurt your arm or whatever it is. It wasn't something that we intended to be permanent. So go ahead, Wesley, you need to break in.
Yeah, Stacie, I don't want to cut you off here, but I think we're getting close to the end, and we do want to get to the Q&A session.
Okay, that's fine.
I'm going to go ahead and take that presenter role back. But yeah, we're going to move into the Q&A session, and if anybody has any questions, feel free to shoot those here. If we can't get to them today, we can address those and send them out. Again, we have a relay service. If you require a video to ask a question, and to get that relay service, please call the number 423-298-2489. Now, looking at we've got some questions coming in here. And our first one is, some people are having lasting issues after having COVID. What do you see as the options for employees returning to work for accommodations?
So, Stacie, Price, if you don't mind, I'll take this.
Oh, yes, please. Yeah, please.
With regard to that, what we're telling employers to do is that you need to utilize the same process that we were just talking about with regard to those who have more what we're going to call traditional disabilities. So if someone comes back from COVID and they're, like I said, that they have some kind of permanent breathing impairment, or like they can't wear the mask because they can't breathe in that. So the employer would need to engage in the same interactive process, again, maybe involving both rehab, maybe certainly involving doctors. They don't just have to take the employee's word for it. Like, well, I want this. Again, usually there's going to be a lot of different players involved in this. HR, again, both rehab, doctors, et cetera, to try to determine the best case-by-case accommodation for each person.
Great. Our next question is, what are some of the biggest mistakes you see employers make in addressing disability accommodation?
So probably the best is not calling your lawyer. ask them for help, or calling an organization like Stacie Price's. Basically just trying to do it on your own, because sometimes common sense is not the best guide. And I'll share with you one quick example of a lawsuit that to a lot of people probably thought, well, duh, this is never going to go to court. We had an employer who refused to hire an applicant who was deaf to be a lifeguard. And the city, they had an expert come in on pools, but they didn't have an expert come in about hearing impairment. So it's like, when they actually talked to an expert that had expertise in hearing impairment, what they learned was that someone actually who is deaf actually is going to be faster than someone who has hearing react to somebody who's signaling, "Oh, I'm drowning," because they don't have all the distractions that a hearing person will.
Wow.
I never have thought that that a deaf lifeguard might actually be better than one that had hearing. So, that's one of those situations where common sense, some city council or whatever said, "Oh, that's insane. We can't have a deaf lifeguard." Well, then an expert in there, they're like, you know what? The studies show that this person actually may be better than your hearing lifeguard. So that's one of those things where that's one of my favorite illustrations of something where you can't just follow common sense. The last one I will tell you is ignoring. It may seem crazy to think an employer would simply just ignore someone who is asking for an accommodation, but unfortunately, sometimes that's probably the other big mistake that I see is employers maybe just kind of hope it'll go away. Well, if I just ignore them, maybe they'll just find some other job, or they'll just they'll get tired and they'll get tired of asking me, and they'll just go away. Well, what's normally going to happen is they're going to call their own lawyer, or they're going to call the EEOC or somebody. They're not usually just going to, quote, go away. So ignoring them is probably the next bad step that I see employers.